Your neighbor can legally build a wall that cripples the economics of your $40,000 solar system. In most of the United States, you cannot stop them. This is not a zoning dispute. It is a property rights problem that American courts settled almost 2 centuries ago. And the answer they chose is now colliding with your roof. The English once treated sunlight as property. Under a doctrine called ancient lights, if daylight streamed through your window for 20 years, you gained a legal right to it. Your neighbor could not block it. The rule had teeth. In 1904, the House of Lords affirmed that an obstruction only needed to make a room uncomfortable by ordinary standards to constitute a legal nuisance. English law protected windows because it treated light as an asset. When American courts inherited English common law, they briefly agreed. Massachusetts embraced ancient lights in 1815. Then the new nation looked at the frontier, looked at the cities it needed to build, and decided the rule had to die. The decisive break came in 1838. The New York Supreme Court confronted a landowner who wanted to stop his neighbor from building because it would darken his windows. Justice Bronson wrote the opinion. He declared that applying ancient lights to American cities would work the most mischievous consequences. The court ruled that receiving sunlight is passive. You do not trespass on your neighbor's land by looking out your window. Therefore, your neighbor does not trespass by building a wall. Because no hostile use of the servient land occurs, no prescriptive period can begin. State after state followed. Illinois ruled in 1855 that prescriptive light easements depressed land values. Georgia declared in 1877 that ancient lights was inherently unsuited to a young, rapidly expanding nation. Massachusetts, which had initially adopted the rule, quietly abandoned it. The message was unanimous. America chose development over daylight. That historical rejection is now colliding with your roof. In 2026, over 3 million American homes have rooftop solar. The average residential system costs between $30,000 and $45,000 before federal tax incentives. That investment only works if the sun hits your panels. But your neighbor can add an accessory dwelling unit. A developer can buy the vacant lot next door and erect a 4-story apartment. If that structure casts a shadow across your array, your solar output drops. Your loan payback schedule collapses. And American property law has a term for the resulting loss: Damnum Absque Injuria. That is Latin for damage without legal injury. It means you suffered real economic harm, but the law provides no remedy. This is not hypothetical. In 1959, the Eden Rock Hotel in Miami Beach tried to stop the neighboring Fontainebleau Hotel from building a 14-story addition. The new wing would cast a winter afternoon shadow over the Eden Rock's pool and cabana area. The Eden Rock argued the structure was malicious and would destroy their business. The Florida District Court of Appeal ruled against them. The decision was unambiguous. A landowner has no legal right to the free flow of light and air across adjoining property. Even if the building caused financial harm, even if it was partly built out of spite, if the structure served a useful purpose, the shadow was legal. Economic harm does not equal legal injury. Then the energy crisis rewrote the stakes. In 1978, a Wisconsin homeowner named Glenn Prah installed roof-mounted solar thermal collectors. His neighbor, John Maretti, bought the lot to the south and planned a home that would shade Prah's panels. Prah sued under private nuisance law. In 1982, the Wisconsin Supreme Court did something no other state had done. It ruled for Prah. The court held that historical justifications for rejecting light rights were obsolete in an era of energy constraints. For a brief moment, it looked like solar panels might create an exception. California rejected that approach 4 years later. Rudolph and Bonnie Scher built a passive solar home with south-facing glass and thermal mass designed to capture winter sun. Their neighbors, the Lightermans, planted evergreen trees that eventually shaded the house. The Shares sued. The California Court of Appeal ruled against them. It explicitly rejected the Wisconsin decision. The court said California's Solar Shade Control Act protected active solar collectors, meaning the roof-mounted hardware, not passive architectural design. Trees grow slowly. Expanding nuisance law to cover tree shade would create legal uncertainty for every property owner in the state. Wisconsin said yes. California said no. And there was still no general American right to sunlight. So, what protection actually exists? The answer is a patchwork of exceptions that prove the rule. Over 30 states have solar rights acts. These laws generally stop homeowners associations from banning rooftop panels and create frameworks for voluntary solar easements. An express solar easement is a written agreement where your neighbor promises not to block your sun within a defined angle. It must be recorded in the deed registry. It is precise, geometric, and rare. Most neighbors do not have one. In planned developments, covenants, conditions, and restrictions, called CC&Rs, sometimes limit building heights. But these are private contracts, not rights, and state solar rights acts can override them if they restrict solar collectors. California's Solar Shade Control Act offers a narrow statutory path. It protects active, roof-mounted solar collectors installed after 1978. If a neighbor plants or allows trees to grow after your installation, and those trees shade more than 10% of your collector surface between 10 in the morning and 2 in the afternoon, the neighbor must trim. But the exemptions swallow the rule. Pre-existing trees are grandfathered. Timberland is exempt. City trees are exempt. And as the Scheer case proved, passive solar homes with thermal glass and concrete slabs receive no protection whatsoever. Some cities have tried municipal solutions. Boulder, Colorado enforces a hypothetical solar fence. New construction cannot cast a shadow beyond an imaginary wall along property lines during a 4-hour window on the winter solstice. San Francisco's Proposition K bars buildings over 40 feet from casting new shadows on public parks. But these are zoning ordinances, not property rights. They protect public space during specific hours. They do not give you a personal entitlement to sunlight. But the part almost nobody knows is still coming. Because there is one narrow exception, and it depends entirely on what your neighbor was thinking when they built the wall. The exception is called the spite fence doctrine. If your neighbor builds a structure purely to annoy you, with malevolence as the dominant motive, you might have a claim. The standard is brutal. You must prove the structure would not exist but for the intent to cause harm. If your neighbor can show any useful purpose, such as storage, privacy, or rental income, the claim fails. In practice, almost no one wins these cases. The doctrine exists as a theoretical safety valve, not a practical shield. The English spent centuries protecting windows from shadows. Americans spent 2 centuries protecting builders from windows. Then, solar panels arrived, and the law had no category for them. Which brings us to the present collision. State legislatures are mandating higher urban density. Federal and state climate goals are pushing rooftop solar adoption. These two policies are fighting over the same resource, unshaded airspace. Imagine House A with a $35,000 solar installation on its roof. That system relies on southern exposure to pay back its loan. Imagine House B, a new 4-story infill development on the lot next door. House B legally blocks House A's southern exposure. House A's system loses output. House A's loan becomes unpayable. And unless House A already has a legal protection in place, it may have no recourse. Courts remain unwilling to create new common law rights to light. They defer to legislatures. Legislatures defer to local zoning boards. And homeowners are left in the middle. discovering that their solar investment may lack legal protection against the shadow of progress. American courts do not recognize an inherent right to sunlight. Your neighbor can build, trees can grow, shadows can fall across your garden, your windows, and your solar panels. If you suffer economic loss, the law has a term for it: Damnum Absque Injuria, damage without legal injury. The ancient Lights Doctrine survived in England. It died in America in the 19th century because a young nation needed to build cities quickly. That choice still governs your roof today. So what does this mean for you? If you are considering solar, understand that your access to sunlight is not legally protected by default. Before you commit to a $30,000 installation, check 3 things. First, does your municipality have a solar access ordinance? Boulder has one. Most cities do not. Second, do your CC&Rs or HOA rules limit building heights in a way that preserves your southern exposure? These are private contracts, and they matter. Third, can you negotiate an express solar easement with your southern neighbor? It will require compensation. It must be written, recorded, and geometrically precise. It is the strongest legal protection you can put in place to keep your panels in the sun. Without it, you are relying on your neighbor's goodwill. And goodwill is not a legal right. The hardware lasts 25 years. Your neighbor's construction timeline does not. And that is the part nobody puts in the solar sales brochure. Subscribe before you go. Tomorrow, we're looking at why the wedding photos you paid for may legally belong to you, not the photographer who took them. And the reason has nothing to do with who paid the bill.